All right, guys. Hello, everybody. Hope you're doing well. We're gonna get to the stuff now tonight that wanted to get to. Mickey Stines. Remember, he's the former sheriff of Lecker County, Kentucky, and he is accused of, well, and I mean by accused, we have him on camera murdering the judge of their town, the judge of Lecker County, Judge Kevin Mullins, and there's no question that he did it. There's no question that he did it. There's no ifs, ands, ors, or buts about it. Like, he's on video fucking doing it. Guys, he's 100% on video doing it. And this is probably one of the, well, actually, here, can show you. Why does it show me so weird in the style thing? I hate it when it does this. Like, I hate it. Yeah, like, that's what I like, or like that. I don't like this classic one is so garbage. That's better. That's better. Although the blue, I picked a deeper blue the last time. I like it like it's that, almost like Prussian blue. Not like that, chat. Not like on Cyclone B canisters. I'm talking about the actual color of the uniform. The video is that video is freaking AI. No, it does not. No, it's not. My mic is low volume. Oh no. My mic is low volume. Hold on here. Let me fix that. Razor. Hold on here. Let me fix that chat. Said my mic's a little low. I turned it up just a hair. Pachito Clyde. Thank you, Pupper. Thank you, Pupperkins. Yes, our good boy Clyde. Oh, and Luke, thank you for that update on David Tamier. We're definitely going to do that, now that we kind of got some stuff to go through. But yes, Pachito Clyde says, get your Clyde approved stickers or grab a mug. Support my dad, chat, at potentiallycriminal.creatorspring.com. Hold on here real quick. Hey, Clyde. Come here, Bubber. Come here. Come here. Hey. Clyde. Hey, Dingleberry. Come here. Come here. Clyde, come here. Come here, Bubba. He's like staring over his shoulder at me. He's staring over his shoulder. Clyde, come here. Come on, Bubba. Come here. You gotta get over here if you want the treats. Come here. Come on. I think he's like, pick me up, fat man. I'm not jumping up to you. And I'm like, you have to. I'm too fat to pick you up. Aww. Here he is, chat. Clyde content is the best part of the show. Yes, he is. Yes, he is. He's such a good boy. He's such a good boy. Anyways, here we go. There we go. All right. All right, chat. So let's get this show on the road. Hi, Bubba. Oh, he's leaning back, chat. He's got something to say. What is it, Clyde? What is it you got to say, Bubby? Huh? You would have done that judge up just like that? Is that it? Oh, he's like, yeah. Oh, such a good boy. Oh, I got you, buddy. I got you. It's okay. You're okay. You want to be on this side, Clyde? Hold on. I got you, Clyde. Oh. Clyde. Dude, come on. There we go. There we go, chat. I guess he doesn't like to be on the right arm, only the left arm. Is that better, Papa? Huh? There we go. There we go, chat. Oh, bless you. Bless you, Clyde Bear. That was such a big sneeze. Oh, such a good boy. Oh, I don't think some nights he likes us, guys, but he's like, what you see, Papa? Huh? Do you want down? Can I put you down then? All right, I'll set you down, Papa. I got you. There you go. All right, Bubby. He's like, I'm going back to 2.0. She's got snacks, probably. Yes, Clyde content is the best. Yes, it is. He's going to go asleep. Yes, correct. Clyde heard Zyklon B and got excited. Yes. Oh, yes. Very true. Very, very true. Jason says, Jason J saying, member for 3 months. Thank you for being here, by the way. Saying, of course, a cop will walk. They earn the hate. Maybe. In the meantime, chat, we do have some more mail that came in. So hold on here. I gotta redact something real quick. This came from somebody in Tennessee. I don't know who. So if you know who you are, then that's you. I'm just going to say the state. But I don't know anything else about you. So if you bet you think this song was about you, don't you? You know, are you that vain? Then these two things came in the mail from Jerry. And I don't know if that's you or you bought it from somebody named Jerry and they're shipping it. But that's what we're talking about here, chat. So let me see here. Anyways, chat real quick. These are the things. So there, these are it. And then there was this. So figure out what they are. So, am I doxing anybody tonight? No. It's a turnpike toll notice. Yeah, that's not how those work here in Ohio. So, are we doxing Clyde? Yeah. Oh, there's a card. Okay. I think this is from Roscoe. He said he was going to send something. So there is a... Let's see here. What is this? Got a keychain. And it says, I heart Bohol. B-O-H-O. Okay. I think it's from Roscoe. Says, Sean, this is a tarsier that lived on my wife's island, the island of Bohol. Okay, cool. Thank you. Let's see, and there's a card. There's a card here too. So, I'm Peppa Pig. Okay, so it is from Roscoe. He says, hope it is more fun than jumping up and down in muddy puddles, even if that is possible. Happy birthday, Sean. I hope you like this card. My youngest picked it out. Thank you, Roscoe. I do like it a lot. Here is a super chat I couldn't send while we were in the Philippines. So I got a Philippine, 1 Philippine peso coin. So there you go. Thank you. Thank you, Roscoe. Clyde is more of a Caillou fan. Yeah. Yeah. Oi, Peppa. It's like, are there any Muslim characters now on Peppa Pig? That'd be kind of funny. It's like, she's like, Mommy, Daddy, why do they try to cut our heads off? 1 Philippine peso is 55 cents. Well, there you go. There you go. That's pretty cool. Now I could buy probably I don't know. Can I buy half of a city block in Manila for this much? I don't know. Oh, Shredder says nope. All right. I'll see what these are here. Yes, Caillou's an evil child from Quebec. Yes, Caillou's evil. Yes. The photorealistic Picks of Peppa will mess you up. Yeah. So what is this here? Oh, okay. Ooh. 1 peso is 2 cents. Okay. Oh, today a peso is 17 cents. Oh no. Yes. Oh, so less than 1/10 of a gallon of gas. All right, so the guys, one of these is here. This is a pretty creative. I like it. It is a shirt that it's slightly small for me, but eventually I could get there pretty quick. Make chat green again. I like it a lot, though. Thank you. I like it. Very good. Very good. It's super chat green. It's beautiful. Yes. That's why you invest in Clyde Coin. It's a better deal. Nice. I like it. It's got the perfect colors. And then there's another one here. I'm assuming this is also a assuming it's the same thing because it's the same place. So takes a I'm guessing a little bit, but yeah. So okay, what the hell does this say? This looks like this was done like direct order from China based on the labeling here. Okay, yeah, it looks like it came from like these were ordered directly from like the Tangent Industrial Mining Concern, to quote the great Ave. I don't know if I like this one as much, but I guess, comes with the territory. I do blog, but I'm not sure that I love trains. So there you go. So, one more. Oh, Luke is saying, Maryland man Kilmar Abrego Garcia filed a motion to dismiss for vindictive prosecution. I mean, either he did it or he didn't. I mean, Safa. It's probably worth a read eventually. Yeah. Either way, he's getting fucking afuera. So, see ya, bitch. Also, apparently, Kelly Deaver from the Karen A trial, she resigned for the Boston Police Department today. So, based on what 2.0 told me. So, thank you for the shirts, whoever sent them in. Yeah, shut up and love the trains, fat man. Oh, does it smell like forced labor? Yes, a little bit. Oh. You found out today Brian Koberger isn't an ally and supports traditional marriage. Well, there you go. There you go. Joe Schmo says, not a good year for my Pinoy cousins. Well, that does suck. Times are good over there. Nick Kreiser for $14.88. I did not see that coming, chat. I did not see that coming. Says, oh, more gifts? Well, happy birthday, Sean. Well, thank you. And guys, like I said, I thank you all for everything and anything you sent in. Once again, I don't understand what I did to garner your appreciation and generosity like that, but thank you so much. It's been a memorable month and a half. Let me tell you what. It's been a memorable month and a half. Let me tell you what. So thank you. Thank you, one and all. It's just a well wish. Thank you so much. 40 feels a little different. Did Kelly Deaver resign due to a sore throat? Probably, and a sore asshole. I'm sure she gave it up however she could. All right. Now, moving on, guys. Mickey Stines. If you guys remember, he is the sheriff out in Lecter County, Kentucky. He baptized the judge in his chambers. And, this is actually one of the shots from there. You could see him with his gun out, putting in work. The judge is hiding in the corner there. Just because YouTube is being so gay with everything, I'm not even showing any movement. Just because YouTube gave me such shit over Thursday night last week, I am not touching any of that. So we're just going to have to suffer with what we got. Just because, yeah. So, Bama's saying, I have experience in Kentucky and will say he will probably walk. Oh, man. If he can. Any mention of a motive in the recent hearing? I don't believe so. And I take a good says, aim, aim, aim. Yes. Yes. Yes, yes, yes. Aim, aim, aim. Spoiler, there are probably no good guys in this story. Does not surprise me. Does not surprise me. So anyway, moving on from there, as this case has progressed, his attorneys, we covered this back when it got filed. And this got filed, I think, a couple of months ago. It's got filed, I don't recall how soon. I think it's maybe filed in June, if I had to guess. But this motion to dismiss got filed. And he got charged. He got indicted for murder. And we already covered this. And what were the issues here? Well, they were seeking a murder indictment. There was the grand jury stuff, and there's some issues here. These are some big ones that were alleged, and we're going to hear about these today. There was a prior meeting between the Commonwealth and the Electric County grand jury that was not recorded. So the prosecutors, the Commonwealth, met, and remember, it's the Commonwealth of Kentucky. You know, the blue moon of Kentucky keep on shining. It was not recorded. That's a big deal. At the recorded meeting, the grand jury sought information as to the relationship between the case of the companion federal civil rights case. Remember, and that is that various deputies and also the judge were involved in basically forcing women who were on probation or probation or other court supervision to have sex with them as part of an extortion ring. But they were deprived of that information. They asked for it and they weren't given it to them. Testimony in response to questions asked by the grand jurors were frequently redirected to deprive them of their independent investigation ability. The grand jury has the right to subpoena whoever they want. So the grand jury can say, we want to hear from so-and-so. The grand jury is an independent fact-finding body. Now, yes, generally what they get presented is good enough, but they can ask for additional things. The Electric County grand jury returned an indictment charging 1 count of murder. Yep. So what happened? There was no meeting of the previous meeting that was there. There has to be transcripts of testimony. And it says failure to have a record made, if required, could be grounds for dismissal. Unless you could show good cause for the failure. And mechanical failure shall constitute good cause. I have a feeling there was no mechanical failure. But the record here has to be made. You know, the court could appoint a stenographer. Or you can take it by a recording device. You could have an audio recorder going. But the record shall be made to include the testimony of all witnesses. And the recording device and a typist, they shall be sworn out by the court not to disclose any testimony. They say in the recorded session, a grand juror references the prior meeting with the Commonwealth. That's the only, remember we went over this. The only reason anybody knows this happened is because of what happened the grand juror mentioning it. Had the grand juror not mentioned this, there might not have been any knowledge of it for a long time coming. Wow, I didn't know that was missing for a while. That's kind of annoying. So, yeah. It's interesting. It's interesting there. So the defendant requested a copy of the prior meeting. The Commonwealth responded, the prior meeting was attended, but it was only for the purpose of obtaining subpoenas. And there was no testimony. Well, are we sure there should be a hearing? Sorry, but we have to have a record. Now, the Commonwealth may seek subpoenas for a grand jury without the necessity of the grand jury intervening. And that's true. When I worked in a prosecutor's office, we could send out subpoenas and subpoena things for the grand jury. We didn't have to have the grand jury convened. So they point out it's curious, why would you need them there? And if a second subpoena was sought, then information must have been presented to the jurors. And if information was presented to the jurors, it's testimony because it clearly related to the nature of the investigation. And regardless of how it was labeled, the information provided constitutes testimony. There was no mechanical failure. Apparently, the Commonwealth chose not to record the meeting. So they talk about the information that's being denied. We went through all this before. The indictment was returned by a legally constituted unbiased grand jury. If it's valid on its face, is enough to call for trial of the charge on the merits. But however, dismissal is appropriate if it influenced the grand jury's decision to indict by these violations, or if there's grave doubt the decision was free from influence. And the court can dismiss indictments where the prosecutors intentionally present misleading testimony. Notice what happens down in like other states. Like people in Massachusetts may look down on Kentucky, but this Karen Reed shit would not have happened in Kentucky. So, and yes, we remember we also went over the video of Mickey Stines surrendering. We went over the video of him talking on the record and getting trucked around. Yeah. If a grand jury session has no testimony, do minutes of the meeting suffice? Well, if there's no testimony, then why are they convened? The grand jury meeting and no testimony showing up or no testimony occurring, there's no need to have the grand jury present. So no, if the grand jury is being convened, there should be recording of what happens. There should be a record of it. So no, I would argue that's not acceptable because if they met, why are they meeting? So, yeah, it's no. Oh, they have new video. I think we did it where everybody goes to tell him, and then he walks in the door behind them. Oh, I'm not sure. Okay, I don't know. I didn't see that. We didn't see that one, but we saw where he's sitting in the hallway, and then he's, he knows he acts like everybody's gonna kill him. They take him down to the Sally Port and they drive him to the jail. We covered all that stuff. But yeah. And remember, guys, this is, all the big problems here that have happened. And this has all been prejudiced. This is all heavily prejudiced. So they want an evidentiary hearing to allow the presentation of testimony. They find that the grand jury was deprived of material information. They want to conclude that the deprivation undermined the integrity of the grand jury and dismiss the indictment with prejudice or grant other further relief. That's proper. And remember, he's got Jeremy Bartley and Gary Bartley, the husband and wife team. They have been out here so far. Another attorney involved, James Cox. So that's his legal team. And this is everybody going forward on this case. So that is where we are at this point. That is where we are. Sarah Brown, I don't think we've seen that video. If you can, I don't know where it's at because I haven't seen that. I didn't know that existed. But yeah, we've seen everything else, like when he's in custody and tells him he did it. So anyway, we are going to move on to the actual hearing. So here we go. Here is the hearing. This is just a quick recap of what we've been through. So also, oh shit. Sorry, guys. Kick is live. There you go, guys. Kick is live now too. Sorry about that. We're on Kick, guys. We're starting the Mickey Stines hearing. So here we go. We've got it going. Remember, guys, this is from 4 days ago. So I believe this happened on Friday. So we've got closed captioning on and I've got sound up. So here we go. And guys, that's James Cox. This is Jeremy Bartley here. That's his wife, Carrie. That's Cox over there. So here we go.
I see Mr. Stines is present. The court took this matter today for the status hearing to address a few matters. I think we're in such a position now where we will be able to set some upcoming court dates to get this matter proceeding. forward. We have been waiting on a KCPC evaluation to be done on the defendant. That has been completed. It is currently under seal.
Now, remember, there was an issue about Mickey Stines pleading insanity, so he had to get evaluated. So the evaluation's done and it's under seal. Nobody's going to see it. I have a feeling the fact it's not being dismissed because he's insane means he probably wasn't found to be insane.
Procedure is done standard in any type of case such as this. That matter right now is under seal. There's been a motion for the KCPC evaluation to be unsealed. Mr. Bartley, that's the main purpose for that is you wish to, if the court does that, and then they get you hearing the other two motions, you wish to have that as potentially useful.
That's correct, Your Honor. Our intention is to have it for the purpose of those evidentiary hearings. I believe that it contains, without speaking about what it contains specifically, that it does contain valuable information that the court would be able to use, particularly in the bond hearing, in terms of coming to, making the court's findings that are necessary to determine whether Mr. Stein is a good candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right. And Mr. Steele, how long, you don't have to respond to that in the notes that yet. How long do you want?
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion. Thank you.
All right. What I would like to do though is at least see how far we can get without addressing the KCPC evaluation issue. In fact, so the court hasn't read that, so keep that in mind. But we can address first the motion to dismiss the indictment. Which started?
Your Honor, I will.
Okay.
Your Honor, we filed a motion to dismiss on 2 grounds. Number one, under RCR 5.16, failure to provide or to have a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that the testimony made in front of the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to the grand jury tape, and there was a reference.
And remember, he's explaining one of the jurors referenced it, and that's the only reason why we know it happened.
Your Honor, I don't know if the court has made that grand jury, can I speak to the content of the grand jury aside from what I think?
Yeah, and the first matter, the court has provided a transcript, a CD recording of that to be used for.
Thank you, Your Honor. So there's a reference to one of the grand juries that said in our last meeting or in our previous meeting, and I'm paraphrasing it. And so at that point, we weren't aware of the previous grand jury here. And so I inquired of the Commonwealth. They did respond to me. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical evidence. And the judge anticipated a response. But I guess, number one, what's odd about that to me is that.
Wait, and that's interesting because they didn't say why the subpoena was for in their motion, but it was for medical records. The prosecutor doesn't need the grand jury to sign off on that. They can subpoena that shit on their own. So the fact they had to convene the grand jury is garbage. This is very weird that they did that. What is the sound? Well, it sounds like nobody got the sound set up right, and I bet it's Kentucky in August. I guarantee you that air conditioner is running real fucking hard too right now. So, Bama is saying these are all normal DPA BS pleadings. Those attorneys are not Department of Public appointed counsel. Everybody in their state shakes their boots over them and their jokes. Oh, okay. The grand jury minutes aren't public. Yeah, I know they're not public, but Stines asked for his previous transcript. He can get it. Yeah, and that's the thing. If Kentucky could just charge it by info, why did they go to the fucking grand jury to start with? That just even more. Why would you even do all this? If you could just information him. So, Yes. Potato Tech things. Guys, remember, This is in fucking southern ass Kentucky. Remember, Lecker County is right next to Harlan County. It is down in the holler. And where they're at isn't much better. They're still in the holler. So.
I've done thousands of interviews, and if you want evidence brought to a grand jury, you should usually submit it at to the hearing. I mean, there's no reason you don't have permission from the grand jury to subpoena. You send a subpoena, you subpoena the custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that it's what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know. And I think the Commonwealth's making the distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is a sworn testimony or sworn testimony. I'd submit to you that the only way you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury said, hey, we'd like to have a correct subpoena. Now, I will say this, I do agree with talking about their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you feel to ask for or form their basis for asking for medical record checks, I think that should have been reported, so we would have that available. And I think 5.6 requires it, and the remedy is that people shall form a motion to dismiss. I can address the other area, Judge. Okay. And the second area, Judge, I really think Canada, that may be an evidentiary hearing, it may not. I mean, I'm not sure. Well, I'll leave that to the Common Office to the response to that. But in terms of the other portion, yes, sir. As to the second portion of my motion, it's based upon come up with a Mr. Cox actually handled Mr. Baker in that case. We all know it. The prosecutor's community is the aluminum bags. The detective goes in and testifies and says, basically it was aluminum bag used. This one used aluminum bag. In reality, it's even more mistake or something like that. And in that case, the following condition and appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you get misleading. And the bigger debate really seems to be after that is it this arises to prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that falls into the value represented to the grand jury. And so when I look at the grand jury transcript, Judge, and again, without getting into the case of piece report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned mental health issues. And the last question before the grand jury retires from the deliberation was, so he was of the same mind as far as the investigation is going, and the answer is yes. That's Detective Stanford testifying. Now, first of all, it's probably not an appropriate thing for Mr. Stanford, Detective Stanford, to be opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts, and I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so this is what I believe. I believe that had they I've been told.
Go back to the beginning. You'll find out.
It's very real. And you know, I can think of one witness, an attorney, who specifically said,
And there we go. Finally, we got some better audio. And this is the prosecutors sitting here.
I think he's had a psychotic break. And so to say that your investigation so far is showing us the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him.
Right.
And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You cited those in your brief.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking.
Right.
Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, then we'd ask you to put on.
Sure.
Thanks, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure.
Well, Bama, I guess, why did they meet with the grand jury without recording it? That just seems sketchy as hell.
Here, the rules specifically that were cited by defense counsel, and we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is the power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as a grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared.
Also, Bama, if you're out there as a Kentucky practitioner or having experience in Kentucky, why would they need to meet with the grand jury to get those? They should just be able to subpoena that shit on their own. This makes no sense. This makes no sense. I've never heard of any state where the prosecutor is hamstrung from being able to secure mental health records and medical records necessary to a murder investigation on their own.
At that time, there was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Okay, yes, that guy's going back, that little thing on the mic and then this thing right here. These little things are the microphones, and this is for like some sort of jabs or other court recording systems. They work adequately for protecting the record. So like a court transcriptionist, court reporter can hear it. But hearing it, this is not what we're hearing right now. We're hearing this through Zoom. So this is like layered audio. Listening to this audio like in the first person sense, it's actually pretty good. But we're hearing this like layered through other things right now. So yeah, it does suck a little bit.
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your
was no peripheral commentary or anything of that?
Honor. No,
matter?
Your Honor.
Well, how do we know that?
Specifically
We don't.
request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Steele,
Just a point of clarification, if I understand your question, as you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health records. They began asking questions, of which We did not have an answer to it.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we needed the records.
Right.
That would have been it.
You know how we would chat, if you guys can hear me, you know how we could know for sure? If there was a record of that instance, if there was the record, if somebody had turned on some sort of audio recorder, we could have verified that. But this still makes no sense why they did this. It still makes no sense why they did it. And Bam, I hope you heard me. I don't understand why they met the grand jury to do this. Like, if you have experience in Kentucky, if you could explain that, I've never heard of a prosecutor that needed to meet with the grand jury to get a subpoena. They could file fucking subpoenas all day long. You're a prosecutor's office. So this is just ridiculous and bullshit arguments. Wouldn't the grand jury's questions need to be recorded? Well, we don't know what was said because we don't know. So. I like to think so. Yeah, and it's health records. But I don't know what the grand jury said in the meantime. But yeah, prosecutors can get all kinds of fucking records. It's not hard. You can subpoena all kinds of shit as a grand jury or as a prosecutor's office. Easy peasy. You know, in preparation for a grand jury, easy fucking way to do it.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued, the records were received, those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not believe it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stamper testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceedings. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is recorded or is required. Sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted to Your Honor.
Thank you.
Your Honor, may I just briefly reply?
Briefly, yes.
Yeah, Judge. So, I mean, I haven't heard anything. I said it from the beginning, Judge. I understand. We're talking about the rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Pollard.
Oh, I get that, Judge, but my point is this: if you put that into context with what they let testify, then I think ultimately, Judge, we put on that evidence will show you that if this grand jury was misled. I mean, the statement, to be honest with you, the statement alone, rendering opinion on saying it is completely, in terms of, I get you don't have to be an expert, Judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should have been admissible or not. That I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury is asking for additional stuff. And so, in other words, if they ask a question and it's germane, I'm not talking about relevance, but if it's germane, it's their grand jury. It's not called a grand jury. They're the investigative body, and so the reason I cited to the things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm going to listen to the recording, and I'll be happy to review that.
And if the Commonwealth,
Please, sure.
thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum back
Understood.
versus a wooden stack
Sure.
stick. I don't think there's nothing even alleged in the pleadings. Even if you take everything in the pleadings that's been said today by defense as true, it would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant.
But you agree it's misleading. You agree it's misleading. You fucking cocksuckers.
At the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I'll get an order out on that. One, if I need to hold an evidentiary hearing in it, if not, I'll rule on it appropriately and distribute that.
Well, no, I get that you need the court authority to do it, but getting a grand jury subpoena, like here in Ohio, like you don't have to, the grand jury doesn't have to it's not that hard. So the idea that you would need the grand jury involved in this the way they did doesn't make a whole lot of sense. Doesn't make a lot of sense to me. But I don't disagree overall the idea of you need court authority for the subpoena. Yeah, you still issue the subpoena, but the idea that they had to convene the grand jury just for this, that doesn't add up to me. So this may not go so well as Ag just stood up. Yeah, nothing is probably going to happen. I doubt the court's going to fucking nuke it. So, but let's be real. The grand jury must have asked for that info too. Yeah, but it doesn't necessarily sound like it. But if they were asking for it, then that means why were they asking for it? Why wasn't that recorded? And that becomes an issue then. Why wasn't none of this recorded? But yes, is this have I seen the sex brothel allegations? Well, I mean, is it that the judge was pulling women out of jail to fuck them to try to in exchange for getting released or whatever? Yeah, I mean that. But I don't know about the rest of it. But yeah, this is just. Now, ultimately, is the judge going to dismiss it? No. This judge is not going to toss out a murder case of a fellow judge on that. That's going to be... it's never going to happen, even if it should. It's never going to happen. So, yeah. I just don't understand this. Sean thought Reed was not guilty. I mean, she was not guilty. So, yeah, I thought Karen Reed was not guilty. It's like, yeah, and she wasn't guilty.
After I've got the CDMS Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the plea.
Sure.
All right. Next, in regards to the bond hearing,
Yes, Your Honor.
Well,
He ain't gonna do shit. He ain't gonna do shit.
Again, Carrie Bartley
Even if he should, he ain't gonna do shit.
for Sean Stines, Judge. And we filed our motion for the court to, and it's been back quite a ways now that we
Sure.
filed that, but we did ask the court to kind of hold
which is
on.
not abnormal. I know we've had some procedural things and evaluations, so
Absolutely.
that
And
is something that
that's-
had to be done
We asked the
first.
court to hold off on setting it for an evidentiary hearing until after we received that report back. Judge, I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We had some witnesses lined up. And I think it'll be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether the bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond in light of the circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash or property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
Absolutely.
any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms
I'm
of his
gonna stop it
pretrial
for a second.
service.
Pretrial risk assessment,
Mhm.
with all candor to all parties,
Sure.
is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on or some other evidence in front of the
That's
court
interesting.
that
I
he would be a
appreciate
flight
that.
risk, that he would not return to court, that he
Thank
would
you
be
for
a danger
explaining
to
that.
himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that case piece of report. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why.
I mean, don't let him near the judges. Keep him out of the courthouse. That's the big thing. Keep him out of the courthouse. There's a judicial conference they need to put on a sign out front. Do not let in.
We're here, judges. I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand,
something else, right? We can't just look at the charge.
but that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would.
50 G's for fucking clipping somebody. Whoa, buddy. Whoa, buddy. And from what I understand, chat, this is inside the Lecker County Courthouse. So this would have been Judge Mullins' courtroom, from what I understand. So a little ironic we're here, but okay.
Put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life.
He was a member up until he killed
the point of his
someone.
arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing
This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Judge, there's nothing that I've seen that anyone's seen. And frankly, when we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct, that he's a low 0 risk, just because this is a man who, again, I mean, you know, there's, with all due respect to the court and to everything that, you know, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. I mean, the actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless is a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There was
Let's
just
look at
recently in
that.
2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298 2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already out there that the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that. It's Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video during the preliminary hearing.
Right.
It's very clear what happens in the preliminary hearing. They were counseled record at the time. So there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to bail.
No, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge, does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed the defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to do the interview staff.
thank you. In response.
Judge, I believe the case I cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm going to try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, Your
with
Honor.
all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday since today's kind of shot next
10
week?
days from, why don't we do this 2 weeks from today?
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly your motions.
rather under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
sure.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, sir.
And you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty chance we have to go through depending on what those
Yeah.
come back as for an expert also. So we made council aware of that also.
All right. Thank you, Mr. Taylor. Anything else we need to address today before we adjourn before the ex parte hearing?
No,
Thank you very much.
All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be cleared. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, sir. I think I would like to.
What's that?
Yes, sir. We wanted to talk to him for just a minute.
Yeah, absolutely.
Take care.
All right.
Thank you.
So, yeah, I told you, everyone's entitled to a bond. Doesn't mean they'll get it, but they do here. Yeah. So, yeah, this is, there you go, chat. Just some more talking. Everybody's having a joke and a smoke. So it's not really, that is, yeah. Says, Your Honor, I believe my client is base beyond belief. Well, Jesus. So yeah, there is that, chat. There is that. Then also, you guys are talking about this sex dungeon thing or whatever. So yeah, Kat is sent. So here we go. This is a, apparently this is something that part of News Nation is covering. This woman was a victim of the judge's sex ring stuff. So this is kind of interesting to listen to here. So let's take a look at this.
You're saying it like it's so normal, but I just want to make sure.
Yeah.
So the judge would have sex with inmates from the jail,
Yes,
and you saw it.
yes. I was part of it. I was one of them. Not just from being in jail, but coming in off the street and seeing them.
How did they keep it a secret?
It wasn't a secret. Wasn't a secret.
Why did you feel like you had to have sex with the judge?
Because he's the one with the power. He holds my entire life in his hands. He's the one that makes the decisions over whether I get to keep my children or not. He's the one that makes the decisions on whether I go to jail.
Did anything ever happen to you in the jail?
I
I mean, because you talk about having sex with the judge, but that was mostly when you were out, right?
Mhm.
Trying to avoid.
Yeah.
Did the judge ever say, you have to do this, or if you do this?
I bet he did.
You come see me 3 times and we'll take care of this. If it's a ticket or something, or you get some minor charge, some petty charge, come visit me a few times. We'll take care of it.
You would say that.
Absolutely.
You guys are awful in your comments.
And how many women do you think were also doing this?
Total over the years, hundreds.
Yeah, it's not just the judge, the guards, a lot of people were
And
involved.
not just for the women who had charges. Like if your man or somebody, your child is in there, then you could go see him for that too.
So you could pay from the outs. It's just like commissary. You could put money on the books. But yeah, it wasn't just the judge. It wasn't just the judge. The guards, multiple deputies were involved in this lawsuit too. Yep. Oh. So, yeah, he was probably fucking the whole county. Yeah. Yep. It's late stage capitalism. Hundreds, well, that they know of, but I'm sure it's gone on to thousands and thousands. This lady has a lot of courage. She does. The locals don't like the police. Yeah, well, down in that neck of the woods, nobody liked the law, really. No one likes the law. So. She said that you could send your wife in to get you out of trouble if she sleeps with the judge or goes on below. Yeah, and that's the thing. You could go rescue your family members and pay their court case off with sex. So there's an interview with a former jailer. Yeah, a lot of courage, no teeth, though. I mean, well, that's just Kentucky. Straight up a plot line from Justified, pretty much. I think, is there a plot line like this out of Justified? I mean, it sounds like it's out of Justified. Sounds like Raylan Givens is unraveling something. And she's done a lot of drugs by her own admission. Yeah, I'm sure she has. You know, guys, this is the heart of Appalachia. This is like poverty run rampant, and I'm not even making fun of it. It's just, yeah, this is coal country, man. You know, it's like Raylan Givens said, we dug coal together. Like, this is, you know, it's just what it is. It's just what it is, chat. Remember, guys, this is when we're talking about like these states, you know, like we're talking about the state of Kentucky. Like, remember, guys, here's Kentucky. There's Tennessee, West Virginia, Ohio, Indiana, Illinois, and Missouri, the states that all border it. And Lecter County is like down here. Like we're down there, guys. We're down there. Oh, actually, we got to get rid of the, you know, like this is a Lecter County. Yeah, I'm sorry. Wrong little stretch up, but you know, guys, this is the heart of Appalachia. These people are poor. It's rough. It's fucking rough in these areas. You know, when you look at like the town, like here's Whitesburg. That's the county seat. This is the county seat. Look what's right down here. Just a ways. Harlan, as in Harlan County, Kentucky. Like you are in the heart of Appalachia. So, oh shit. Okay. Sorry, guys. When you're dealing with like these people making fun of them being poor, you're in the heart. Like, this is the edge of Kentucky and Virginia. I mean, you are in the Shenandoah Mountains and the Appalachian Mountains right here, guys. Like, it's, you know, it's rough. You know, like this is not. If you guys need understanding, like Blacksburg, it's right here. That's Virginia Tech. You can go further up the Shenandoah River Valley. You have Lexington. But like, yeah, here you are. Like, here's Whitesburg, county seat. And what's just down the road? Not too far away? Harlan County, Kentucky. Like, this shit where Justified was. These people are in the heart of, yeah, these are the people, well, the Sacklers destroyed them. You know, hillbilly heroin came through. But even before that, guys, this is fucking coal country. You know, these people, so like, you know, hard scrabble crackers. You know, having to deal with everything in life. I mean, these are some hard ass people who their families have been here for generations and have been through some hard ass times. Like that song, like there's some long, hard times to come. Like that's no joke for these people. You know, they mined coal for the longest time. Now they don't no more. It was the only thing they had. That's all they got down there is mining coal. You look at a place like this, you think you're farming here a lot? You're not farming. Look at all this. Look at all this ground. Look at all the hill. Like, and these are haulers, man. Like, it's not like little foothills. Like, it's not easy to live in these areas and make a living. You know, you've got some of these places, like there's this, you know, right along all this stuff. It's, you know, if you guys have never been to these areas, like I've been to this end of Virginia here, down in the corner. Like, it's very interesting. You are in the middle of fucking nowhere. Roughly. Like, there's a lot going on. And, you know, and here's like it's just completely wooded over. The state border just completely wooded over. And you're in the middle of a valley. It's kind of roughly how they drew the state line out. You know, this is what it is out there. So P-Dub says VMI. Well, yeah, but that VMI. Okay, well, VMI is all the way up the Shenandoah Valley, though. Up here in Lexington. That's VMI. It's also Washington and Lee is right there. And then there's VMI, the premier military school in the United States of America, the premier military institute. So, but yeah, that's just rough times. Hokie Nation, yeah, well. Bowling Green's the heart of the production of Corvettes, yeah. Mm-hmm. Just travel to small towns on Google Maps, yeah. Hazard County, Kentucky, you can hunt elk? I didn't know you could hunt elk in Kentucky. That's pretty cool. This is Hillbilly Elegy. Yeah, Elegy, yeah. Although to be fair, where J.D. Vance grew up was in Ohio, but yes. No, we're not in West Virginia, guys. That's where Johnson City, Tennessee is. Yeah, that's the problem. If you follow the lyrics to Wagon Wheel, if you're heading to the south out of Roanoke, and you catch a trucker out of Philly and you have a nice long toke, you know, he's heading west to the Cumberland Gap. Well, the Cumberland Gap is all the way up here. The Cumberland Gap is, you know, as you're going to Hagerstown. So this is the Cumberland Gap up here, because the Cumberland Gap is the opening to the Shenandoah Valley. And the Shenandoah Valley runs all the way along Virginia like that, along the mountains, along the spine of Virginia. But yes, if you're trying to go to Johnson City, Tennessee, you can't head west to the, you know, because if you're heading to the south out of Roanoke, you know, how are you going west to the Cumberland Gap and then go to Johnson City, Tennessee? It doesn't work that way. I mean, you know, like it doesn't work, chat. I mean, you know, and also I don't know how far down you can make the coast in 17 hours, because clearly you are not on the coast. You are hundreds of miles inside of Virginia. So I don't know how you can do that, because if you made it down the coast in 17 hours, where the fuck did you start? And then, I mean, you can pick bouquets of dogwood flowers, but I don't know if you're going to make it to Raleigh to see your baby that same night. I just don't think it'll work. It just doesn't work geography-wise, chat. Stacy said, I'm proud to be a coal miner's daughter. Yeah. So I live in West Virginia. The southern part of my state is fucked. That too. Jen says, anytime I feel bad about being born in Ohio, I remember my brother and sister were born in Kentucky. Stacy says, Washington and Lee has a law school. Yes, they do. They do. You could thank John Rockefeller for reforesting the Shenandoah and Appalachia. Yes, he did. DK Cripple says, ha ha, VMI. Go talk to people who've been to VMI. They've like, ain't like them faggots up at West Point. VMI is a real school. So, yeah, elk were reintroduced in the mine country. Yeah. So, Wagon Wheel, bro. I'm on Travis Tritt, homie. Well, I'm talking about like Old Crow Medicine Show Wagon Wheel, not the Darius Rucker one. Adam says, wait, what kind of gap is it? The Cumberland Gap. The Cumberland Gap. So, here, hold on. Okay, so real quick, this is the state of Virginia. And right here is the Shenandoah River Valley running along here. Okay. If you get into this, I mean, you can see it. See how there's mountains along the sides? Like, look, mountain ridge, mountain ridge, mountain ridge, mountain ridge, mountain ridge. In here, in the middle, this whole area right here, this is the Shenandoah River Valley right here. It's actually beautiful stretch down I-81 if you ever get to drive it. But this is the Shenandoah River Valley. And the Shenandoah River Valley, the Shenandoah Valley, you know, you get all the way up to here. And the entrance to it is the Cumberland Gap. And the Cumberland Gap is right here outside of Hagerstown. So when you're coming through and you're coming your way into like DC, you're going across the bay, right outside of Hagerstown, you'll see signs for the Cumberland Gap because it's like the opening door to the beginning of the Shenandoah River Valley. And you take this all the way down. I mean, like, it's beautiful. Like, look at it. Full of agriculture and going all the way down. Notice it's mountains on both sides. You know, you're going down, going down, going down. You know, eventually you get to Roanoke. It's kind of the terminus of all that. But notice, look how, like, goes right along Virginia like that. So, yeah, it's a place. Did the dude's hitchhiking? There's a lot of side quests. Well, yeah. The Gap's at the bottom of Virginia. I thought Cumberland Gap was in Maryland. Yeah, hold on here. Oh, shit. I thought the Cumberland Gap was on the north end. So what's the north end of it? Fuck. All right, yeah. So the Cumberland Gap's all the way down here. There. Cumberland Gap's the entrance. My bad. My bad. There's a Cumberland Gap in North Carolina. All right, so my bad there, chat. You still can't go to... Yeah, I'll be wrong. See, chat? I was wrong. No, the Devils go, so I didn't know how to read the map, why? But yeah, see, you still can't go because Johnson City, Tennessee is over here. He's heading west side of the Cumberland Gap. You know, doesn't work that way. So there you go. So the Cumberland Gap is yeah, I see it now, chat. Wrong gap, Sean. Okay, yeah, there you go. Okay. Yes, tech guy, I see. So something you'll never hear in Ricada Law. Well, that too. Yes, chat. So play the second string Carolina band Cumberland Gap song. No, we're not doing that. So anyways, chat. So we're all done. I'm actually we're gonna hang this up because it's 10:20. And yeah, we got 2 shows in tonight, chat. We got 2 shows in. Jason says that he thinks a cop will walk. Jim Cox said, member for 18 months, says, it's not me representing Mickey Stines. Well, there you go. Pro gamer Nick your lips. Just flipping and flapping out there. For $2 says he is innocent. The judge threatened to A-log him. Well, there you go, chat. That's how you know it's for real. In real life, if someone threatens to A-log you, you could kill them, apparently, in Kentucky. Another says Kentucky's a beautiful state. Yes, it is absolutely stunning and beautiful. So I'm thinking of the Cumberland Narrows. Okay, well, there you go. So, yes, I got the wrong hole, chat. So, yeah, I'm sure Nick will be like, whoa. You know, when you have the Maillard effect and you're in the Shenandoah River Valley, like everybody knows. I'm sure he'll regale us with his geographical knowledge. You know, I bet Sean didn't even know there was an 4 F-35s and a B-2. For what? I don't know what you're talking about. So the judge needs 2 weeks to decide. Well, it's going to take him some time. Remember, this isn't his only case. Nick Ricada told me it was legal to air condition the judge. That's been buffing my wife, bitch. Oh. You're at the front. We were looking for the back for the gap. Yeah. Oh, the flyover in Alaska? I actually hadn't watched any of that, so I didn't know there was a flyover. If Trump made a flyover as like Putin landed and walked out, that's fucking epic. Just as a big fuck you to Putin. It's like, a couple of your fucking Su-35s flying into formation are yawn-tastic. We got fucking 4 F-35s and a B-2 because we can afford to do that. So I don't think he could scrounge together enough F-30 or Su-35s to do a flyby because they're all busy doing, because of all their fucking losses right now, they have to keep them on the front. A flyer with a B-2 as well. Yeah, there you go. The Su-30 junk. Now, the Su-35 is a formidable platform if used properly, and I bet if you gave it some, I bet it's got a decent enough opportunity. I mean, against F-35s, it's toast, but it's holding its own against like all the dog shit that NATO gave the Ukrainians, the F-16s and the MiG-29s. I mean, it's swatting all that shit out of the sky. 4 F-22s were on the ground and the 4 F-35s and a B-2 flew overhead. I saw the picture with the F-22s in the background. That was nice. The Sukhoi says what? Why are you saying that means to the Sukhois? They're so good. They're nice airplanes and they look sexy. They're cool. The Su-35 looks pretty cool. The Su-35 flies over and gets tagged by Ukrainian drones. Yeah. The Su-35 just starts chucking fucking GBUs. Well, actually, it'd be funny if they had a couple of MiG-31s fly over, and as they flying over, they got Kinjals and just go, and just like a Kinjal fucking volley getting sent toward Kiev. That would be hilarious. So, all right, chat. I think we're, you know what? Hold on here. Let's Google this because I didn't actually see this. I didn't realize people were like all fucking upset about it. Let's see here. Let's saw her. Let's see, chat. Alaska flyover. Okay. Oh, okay. Here we go. Got it. Here we go. Okay, let's take a look at this. Okay. That is fucking epic. He's like, Vladimir, I can send those to fucking Moscow anytime I want to, and you can't stop them. S-400 what? That's pretty hot. That's pretty hot. Look at that. Look at that shit. Although, I do think the F-22s there is pretty dope. The F-22s being there dope, but yeah, this is good. This is fucking, look at that. You know, that the only thing better is that they had Man of War playing in the background. So, I was thinking the Cumberland Road. Okay. Well, thank you, AT1. I was pretty close. Putin was happy to see something that cool. Of course, he's a dude. He's like, Wow, planes. Well, it's like 2.0. She's laughed at it before. Like, if we're sitting here in the house and I hear like a helicopter flying over that doesn't sound like the normal general aviation traffic, I'm like, what the hell is that? Or if you hear an airplane flying over that's not normal, you're like, where the fuck is that? What is that? So, Cactiism says, can we get anything more interesting? The early stream in this one we're lacking. Yeah, we're trying to cover everything, man. Sometimes it's not going to be, sorry, it wasn't your cup of tea tonight, but this is, I thought some relevant stuff to cover. We'll be back to covering other stuff. Hopefully you'll be all right going forward. So it was hot. Yeah, that's hot. Are you telling right now? You don't think that's hot? This is hot, chat. Like, look at that. That is so cool. That is fucking sexy. So, Putin gave Alaska man a new commie motorcycle while I was up there. Oh, okay. I just like the Cessna cruise missiles. Yeah. Everyone smiles at the Dorito. Yes. Yes, the Dorito, the spoopy Dorito. Yes, everybody smiles at it. You can do Iron Maiden, Aces High. Yeah. There's a lot of songs you can play. So. I used to work at a school in the flight path for a naval base. We used to look for skid marks on the roof. I'm just saying B1's buzzing the tower while the flyby would have been even better. Would have been fucking dope. Yeah. Yes, that would be funny. That would be very funny. You like how habitual line crosser uses a surfer dude voice for the B2? I haven't watched enough of his stuff to hear him talk about it, so. It's the Cool Ranch flavor. Panzer Dude says, well, are you saying B1s are nice? Are you talking about the B1R, which is nice? Because those are two separate things. Because if you don't know about the B1R, that is a cool concept that never came to life. And the B1R was a concept where they'd load up, they would retool the B1s to basically turn into basically a dump truck full of AMRAMs. And so basically he'd be sitting off in the distance and there's an AWACS lighting up targets and he just sits there ripple firing like 40 or so AIM-120s and chucking extended range AMRAMs into a threat before they even encounter the main fighter body. It's a pretty cool concept. That never materialized. But think about how many AMRAMs you could fit on a B1. You could do external fucking pylons for that shit too, in addition to the two bays it has. Yes, it would have super cruise capability. Yes, because it has the same engines. Yep. Ego says that's cool. Yes, very fucking cool. Very fucking cool. Very fucking cool. I mean, when you think about the payload of a, hold on here. We got now we're chat. See, now we're doing something I hope you guys like. B1. Okay, let's see here. B1 bomber. All right, the Rockwell B1 Lancer. What are the specs? Okay. Performance, armament, 6 external hard points with a capacity of 50,000 pounds. Okay. So they have 2 bomb bays. Remember, the B1's got a forward and rear bomb bay. So, it's got 3 internal bomb bays. So over 43 or 75,000 pounds of ordnance. So total, you could have 125,000 pounds of ordnance. And how much is an AMRAM? And the AMRAM stands for Advanced Medium Range Air-to-Air Missile, chat. If you did not know, here we go. The AIM-120 AMRAM. Let's see what we got here. Yeah, that's 33 tons of hate. Yes. Yes, this has always been a plane channel, yes. So. So, let's see here. So how much does an AMRAM weigh? Propellant weight. No, I won't wait. Warhead weight, I'm not worried about that. What's its mass? Oh, 356 pounds. And length, it's 12 feet. Okay, so I mean, like, if length, I mean, like, the biggest thing is you can only store so many at a time. But, like, let's just do some math. If it was solely based on weight alone, its mass is 356 pounds. Okay, so 125,000 divided by 356. It could carry theoretically 300. It could carry 351 of these theoretically. Panzer Dude says you could probably fit 130 of them. Yeah, that would be hilarious. I don't know if you could fit 130 of them, but you could probably do a lot. You could probably do 40 or 50. Think about just 40 or 50 AMRAMs. Like, let's say that number, 50 of them. And that's a neat part about an AWACS. It can light up the target for you, and you could have your radar on, and it's just receiving passively. And the missiles can also passively receive radar data. So you don't even have to have your own radar on. The fighters don't have to have radars on. AWACS could do that. And imagine that, just fucking like 50 AMRAMs just scoosh right out into the world. And just fucking B1 takes off, flies back. 50 AMRAMs come screaming in there. Just that's so cool. That's so cool. Iowan Lawman says, as a dedicated Frogfoot and Hog enjoyer on DCS, this is the bane of my existence. What, the AMRAM? Oh no. How is the Frogfoot on DCS? I didn't know. B1 is fugly. The Kremlin shared a video shot inside Putin's aircraft during the return flight. You should check it out. It was funny. All right, let me see if it's up there. We'll take a look for it. All right, let's see here. All right, let's see. I don't see it, chat. Tell me what it is, because I don't see oh, here we go. I don't see it, chat. I don't Oh, here we go. I see it now. Yes. Here we go. Here we go. So let me see here. That's a menacing sight. Couple F-35s, like, pretty damn close. And you know those things are on right now? They are, I guarantee you, they're carrying some electronic collection pods. They are sniffing for any sort of emissions coming off of that aircraft. If it's transmitting any data, these guys are fucking hoovering it up for intelligence purposes. Interesting. There we go. So, you want to fire AMRAMs off? You want to fire the AMRAMs off the F-15EX? Well, you could do it off both, but the idea is you have AWACS running the radar going and nobody else, and then you just start using AMRAMs as you want. But the F-15EX would work in conjunction. It's just you've got a dump. In the meantime, your B-1 is literally a dump truck full of missiles. So all the planes are flying with Putin, yeah. I wanted to see the pilot wave. Well, he's not going to wave. He'd probably do a wing waggle. There is one that shows his reaction to seeing them too. Oh. Well, I mean, like, there's also the one where it shows, like, the, the Su-35s flying in formation with him too. So, yes, I agree. The EX has more range and payload capacity than the Raptor. It does, but it doesn't have super cruise or stealth, low observability. So, you'd work with them hand in hand. They would work hand in hand. So. What's the Ozempic vulva news? I don't know what that is. Anyway. Yes, always more DACA. Always more DACA. When you can. So. All right, guys. With that said, we are going to land the planes, proverbially. We are going to land the plane tonight. We're going to take care of that. Did you see the Labor government lied about how much the cost of giving away Diego Garcia was by a magnitude of 100? Yeah. Google Ozempic vulva. No. I don't know if I want to. So this is what peak performance is like. It is, chat. 2 shows tonight. 2 shows tonight, grinding it out, getting it done for you guys. Like I said, I know some of you didn't like this tonight, but stuff had to get done. We got to get stuff caught up, and I want to give you guys the stuff you're talking about, and don't want you to feel like you're getting left to hang. So we're taking care of that. And hold on here. Why do all these? Very weird. Very weird, chat. All right. Hmm. Hold on here. Oh, wow. They sent that like super late. I'll have to talk to them tomorrow. I hate how they fucking do that. These courts fucking send emails like 4:30. You're like, bruh. So there we go, chat. The Frogfoot T is free to play in DCS. Ooh. Oh, I guess. So. You're referring to the planes escorting Putin. Well, I'm sorry. Go look at the Rapid Dragon, turning cargo planes into cruise missile things. Yeah, but that's something that's been tested forever. They tried to launch a fucking Minuteman out of the back of a C-141. So, yeah. That's not a new idea. That's not a new idea. So they tried to air launch a ballistic missile. Pretty based idea. I mean, why not? But it's not a new thing. Not a new thing. Courtney Clenny has a hearing tomorrow. Well, we could start getting into that because it sounds like that they're going to start making some forward progress on that. So, all right, chat. I will see you guys tomorrow. And remember, until next time, chat, just because you did it does not mean you're guilty. And it sounds like there's some argument to be had that Mickey Stines may not be guilty. I don't know necessarily if it's going to work, but yeah, he's probably going away. Well, yes, he did it, and he enjoyed it, it sounds like. So, chat, have a great night, and I will see you guys tomorrow. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?